we return now with our second installment in our tax audit series. Hi, everybody. This is Jim Mitchell here on Chicago's Legal Latte. And I welcome back to our podcast from Lavelle Law, the managing partner, Ted McGinn, and shareholder Timothy Hughes. They were with us in our first installment where we talked about audits. Today, we're going to talk a little bit about tax debt. And I kind of doing a quick intro here because there's a lot to cover and I want to get to it. But before we do that, Ted, maybe just a quick recap, high level of some of the things we talked about in terms of tax audits. What does that mean? And what should people be aware of going into this conversation?
Yeah, Jim, thanks for having me again. Glad always to be here. So as far as what we covered last week, we did spend some time talking about audits. Essentially what an audit means, the IRS is questioning items that's contained on your tax return. There's desk audits, which are kind of handled via the mail. Then, of course, there's these audits that take place in person. If you are being audited, we would always recommend that you have a professional that assists you to make sure you have the required documentation to support any sort of positions you may have taken on the tax return. And then furthermore, we also discuss your rights to appeal. If a decision comes down adverse, there are some certain appeal rights, whether that means going to IRS appeals or possibly even filing a petition with the United States tax court. There are some possibilities, and you don't have to accept whatever it is that the IRS comes down on, in the course of the audit.
And that conversation is available at lavellelaw.com, also on the Lavelle Law YouTube channel, and an audio version available on Blog Talk Radio, so people can kind of catch up. But as we move ahead here today, let's talk about tax debt. We put ourselves in a position here now where an individual or a company, it has been determined that they do owe the IRS or perhaps the Illinois Department of Revenue. Tim, what happens next? There's a tax bill. How does the process play out from there?
Yeah, there's several tax bills before typically a human being at the IRS will start trying to really reach out to a taxpayer. And at that time, then if the taxpayer is unresponsive, the IRS will take steps of possibly filing a lien, which puts the world on notice that the individual or individuals, if it's a husband and wife, owe the IRS money, or they can start reaching for a paycheck or paychecks if it's a joint account, and bank accounts, in which case then the taxpayer wants to address that liability quickly.
And we talk about that liability, and Tim, you and I have had many conversations and discussions on podcasts in the past. I know you've done a series of videos. If it's an individual or a couple, chances are they're having some financial problems. That's why they're in arrears. Once a settlement or once a decree is put forth, what's most important now? Staying up to date on current taxes or paying off the debt if they can't do both at once?
Okay, just real technical. It's not a decree. When the IRS makes an assessment, then that's receivable on the government's books. Once
Sure.
that is on their books, you want to contain that problem, because going forward, you want compliance or minimize the damage. Penalties will max out at 25% for failure to file, failure to pay. So if you can contain that to a period or a small number of periods, then your overall liability will be lower and it's easier to hopefully deal with the IRS.
Let me also jump in here, Jim. There's a constant theme when you start talking to the IRS to resolve a tax debt. Mm-hmm. And that is they want the taxpayer to, moving forward, to be a good taxpayer. Or to put it a different way, the IRS is typically reluctant to whether it's an offer in compromise, whether it's an installment agreement, whatever the case may be. The IRS is reluctant to compromise or negotiate with the taxpayer if the taxpayer continues to incur new liabilities. So often we're trying to encourage our client to, at this point moving forward, you got to be a perfect taxpayer.
Now, you mentioned some things that I want to talk about, some different tactics. We'll get into those. We talked last time about trying to solve the issue, perhaps dispute it, show some facts in the contrary. But again, if there is a debt, is the IRS open to negotiation at that point?
Yeah, I mean, there are a number of strategies and procedures in place that a taxpayer can utilize in order to resolve their tax debt. Sometimes they may be eligible to get some savings. Other times they may get some time to pay it off over a period of time in the future. Before we get into the different possible strategies, I think we should spend a little bit of time talking about a collection due process hearing.
Okay.
So once the IRS has assessed the tax, you got a tax liability there. Before they want to go into enforcement, whether it's a levy or a garnishment or even filing a lien, they send out a final notice, and that gives the taxpayer what they call a collection due process hearing. Tim, you want to talk about the collection due process hearing procedures?
Well, the collection due process hearing allows the taxpayer to hopefully resolve it at the appeals level and not have their file go into collection, where, as I mentioned earlier, there could be a levy on a bank account or a paycheck or some other asset, or even, as Ted mentioned, the notice of a federal tax lien being filed. Because for some individuals, S-corp individuals who their name is the credit worthiness for getting an asset or keeping their business going, notice of federal tax lien could be kind of the end of that business, or very costly for getting future credit. So getting the matter resolved at appeals is a nice way of resolving the matter before it kind of quote unquote goes public.
Any of these options seem like they're probably out of the reach of the average taxpayer. Is this where an attorney comes in, a CPA? Who should be helping?
Well, most CPAs like to prepare the returns, but once it gets into collection controversy, they don't necessarily feel comfortable. So we practice in front of the IRS Monday through Friday. So knowing their policy and procedures or their internal revenue manual, feel very good and comfortable in helping a taxpayer get the best resolution.
Also, I think now's a good opportunity to add, Jim, that there are a lot of shaky outfits out there that will try to take advantage of taxpayers, and they don't really understand the procedures. They don't do a good job of negotiating with the IRS, but they do take a lot of money from the taxpayer. Sometimes these are out-of-state companies that will do this, take a large upfront fee, and really do very little, if anything, to solve the taxpayer's problem. So it's buyer beware out there. I think anybody in this situation, I would recommend them contact a local attorney rather than some out-of-state outfit to do that.
And we have mentioned that in the past, and clearly those ads are out there. They use a lot of scare tactics. They present themselves as being very capable, but I believe you said last time that only attorneys can handle certain things in the first place, and you need to have an attorney representing you.
Well, not exactly. They have enrolled agents, which they're a step down from attorneys. It's not too terribly difficult to become an enrolled agent. You fill out an application with the Internal Revenue Service. They are able to work with the IRS. Now that doesn't mean that they are capable necessarily,
right?
But you do not have to be an attorney to represent a taxpayer before the IRS.
Ted McGinn and Tim Hughes are with us from Lavelle Law as we talk about tax debts today in the second part of our three-part series on taxes. And we'll have some upcoming conversations with them as well. But today we focus on the debt aspect. And if one of you could help address this, because Ted, I think I heard you say something about a payment plan. So if in fact there's an amount due, is that something that the IRS is willing to work with you on?
Yeah, the IRS definitely is willing to work on a payment plan. Now, how much you pay per month, that generally is a function of the taxpayer's available cash flow. So there is kind of a detailed, extensive process that is used to determine how much that monthly amount should be. But bottom line is an installment agreement is a great way to satisfy your tax liability. You don't have to worry about your bank account being levied or your wages garnishment, as long as the taxpayer continues to make the agreed upon installment agreement payments. I should mention, with an installment agreement, interest continues to accrue on that tax liability. So you're probably going to talk about offer and compromise next.
Mm-hmm.
The installment agreement, the taxpayer does not get a savings over interest and or penalties. The full liability is going to be paid. It's just that the taxpayer has additional time to do it.
Does the IRS generally have a period that they won't go beyond in terms of payment plans? Is it by this date we have to have it resolved?
Well, they can't go beyond the collection statute period, which is for 10 years for the IRS, 20 for the Illinois Department of Revenue, to enter into a simple installment agreement where you're not giving financial information. They typically want 72 months. If it's going to go beyond 72 months or the liability is over 50,000, then there's going to be certain financial disclosures that have to be made.
And then let's talk, as you mentioned, Ted, about offers and compromise. This is, I know, a tactic that has been available for some time and probably not as highly recognized by individual taxpayers as it could be. What can you tell us about that?
Yeah, offer and compromise is a good opportunity for a taxpayer to get reduction of what they owe the IRS. However, it's not something that is given automatically. It's a function of the net worth of the taxpayer. So if you're a taxpayer, you owe the IRS, $50,000, but if you have, $500,000 of equity in your home, well, the IRS, they're not going to really entertain an offer and compromise there, because in that situation, the taxpayer has the ability to satisfy that tax liability. On the other hand, if the taxpayer does not have assets or has assets less than the debt owed to the IRS, that's the type of taxpayer that would be a good candidate for an offer and compromise.
And what about, we mentioned payment plans. Can the IRS garnish wages? Can they simply begin to take this money on a monthly basis?
If there's not an agreement in place, yes. Short answer is yes, they will. And unlike a judgment creditor in a lawsuit, which is limited to taking 15% of the after-tax amount of a taxpayer or a judgment debtor, the IRS will basically leave you with about 15%. So a IRS levy is not a long-term solution for a taxpayer, because it's just too draconian of a penalty on the taxpayer. It's meant to wake up the taxpayer to the liability and force them to come to the table.
Well, and if you're a business taxpayer, a garnishment, or actually a levy, I should mention, is just a severe sanction to a business, because in that situation, they levy the bank account of the business. That chances are the business is expecting to use the cash in that bank account to pay off creditors, vendors, payroll, whatever the case may be. And the IRS comes in with a levy, the bank is going to immediately lock down whatever funds are in that account. And it really puts a stranglehold on the ability of the taxpayer to operate their business. So that levy is kind of a severe sanction. Now, you have 21 days after the levy hits to try to work out a deal to get the IRS to release that levy. But that's a very big challenge to get the IRS to cooperate. And 21 days is not a lot of time.
Well, it sounds too, from what you have both shared today, that if you get into this situation of having debt, the IRS is pretty active in digging into the finances individually or of the business. When we're talking about equity in a home or your cash flow in the business, they're going to want to see a lot of financial records. So it sounds like this is not a simple process, and they're going to be very active in finding how you can pay.
Yeah, I would agree with that. I mean, as I mentioned before, to be eligible for an offer and compromise, the taxpayer needs to be prepared to demonstrate that their net worth is less than the tax liability. And that means substantiating their net worth, or how much money, what their wages, what their equity in their home is, what their business is worth. A lot of documentation and record involved with that. And with an installment agreement, as Tim mentioned, if it's going to go beyond, a 5-year, 6-year installment agreement, the IRS is going to want to see, what is this taxpayer monthly income? What can this taxpayer afford to pay on a monthly basis? And there you get into the substantiation again.
Is there something known as abatement that factors in here?
Now, Tim, go ahead and handle that.
Sure. Abatement is abatement of penalty. It's not an abatement of tax or interest, but penalty. And penalties can be 25% of the unpaid tax at the time of filing. So it can be a substantial amount. Typically, you need reasonable cause, saying why you were stopped from filing or paying on time. But there's certain exceptions or other abatements. First-time penalty abatement, if you have a clean record for 3 years prior to and haven't done a first-time penalty abatement. Also, kind of getting a little into the weeds here, but for business taxpayers, if there's a trust fund penalty assessed against individuals of the corporation, that's a penalty, and that could be abated if you can show you were not responsible for the accounting, collecting, and remittance of the payroll taxes.
And I'm going to ask a novice question here. And as we get near the end of the podcast today, you can certainly defer this one and say, nope, that's a whole other topic. But in the process, I assume there are some people who, just for financial reasons, fall behind on taxes. There are probably others who manipulate, and whether that might be considered fraud or criminal behavior. When there's tax debt, does the IRS get into that? I mean, is there the possibility of some form of criminal charges coming out of this?
Yeah, I think it's always a possibility, depending on what type of liability we're talking about here. I've dealt with interesting cases before. Tim mentioned the trust fund penalty, and just so our listeners understand what that means, that's employment taxes. And if you operate your own company and you're not paying employment taxes, but then that same person, they file their individual tax return, the 1040, and they take as a deduction the withheld taxes from their paycheck, but they know those taxes weren't remitted to the IRS. So that's an interesting sort of, quandary that a taxpayer can find themselves into, and seeing some potential criminal activity there. But yeah.
All right, so I think what I'll do here is set us up for our next conversation by simply asking, after all of these options have been exhausted and reviewed, what if someone simply cannot pay the debt? What happens?
Well, you've heard it before. It depends. It depends how much time is left on the collection statute. It depends, is that inability to pay temporary or long-term? It depends upon the nature of the taxes and the amount of the liability. So there's not one answer fits all.
I think, Tim, what he wants us to say is bankruptcy.
Well,
Can't say that. It depends. It depends.
Yeah.
I think we will use that as our jumping off point for our next conversation. We'll talk about bankruptcy. We'll talk about some options there for individuals and businesses. So Ted McGinn, Tim Hughes, thank you very much for being with us on this installment, and we'll look forward to having a conversation soon as we continue our series on tax debt. Thanks very much, guys.
Okay, thanks.